Hello everybody and welcome to today's webinar. Before we start, just a couple of housekeeping points. In the interest of timekeeping, the delegates are on mute, so if you want to nibble on your sandwiches, that's absolutely fine throughout the presentation. And if you have any questions, just make a note and you'll have a chance to submit them through the chat window on your screen. If you would like a copy of the slides, please do drop me an email, but this webinar is being recorded and you'll be sent a link to the YouTube channel at the end of the webinar. So please don't worry about if you miss any details or noting everything down. So back to the presentation, a warm welcome to you all and thank you for joining me. My name is Salma Manzoor and I am a commercial property solicitor at Edward Hanson Lewis based at our Leicester office. EHL are a high street firm of solicitors with 12 offices placed nationally, covering a wide variety of areas such as litigation, employment, property and corporate, to name a few. In today's webinar, we're going to be focusing on freehold properties versus leasehold properties and the advantages of each. I'm going to cover what factors to look out for when you're sourcing a property to buy or rent and how to increase your returns on rental properties and the longevity of your tenant's staying power. So when it comes to property, we often see words like freehold, leasehold and covenants thrown around. I'm just going to run through the definitions and characteristics of these very quickly. So what's a freehold? Owning a freehold means owning the building or property and the land that it stands on outright in perpetuity. A freehold property will often form part of your estate and can be passed on to your heirs when you die. As a freeholder, it will be your name on the land registry title deeds and you will own title absolute. In other words, you'll have the best class of title available without fetter in the deeds. Effectively, the property and land is yours to do with what you like, at will, save for any covenants that might affect the property in the deeds. Covenants are promises to do certain acts or conversely refraining to do certain things that affect the land, whether leasehold or freehold, such as maintaining certain walls or fences, not obstructing paths or driveways, not encroaching a neighbour's right to light. So what are the potential limitations on ownership of the freehold then? So we go back to covenants in the lease. They are potential limitations, such as the ones mentioned earlier. We've got planning obligations and limitations, such as extensions, redevelopment will need to be approved by the local authority, or the property might be in a restricted development area. And repair and maintenance, so that's always up to the freeholder, but naturally, in order to enhance the value of the property, the freeholder will keep the property in good repair. Back to leaseholds now. What is a leasehold? A lease is a legal contract between a freeholder and a leaseholder to occupy the property for a number of years in return for rent. The leaseholder, or more commonly known as the tenant, will never own the land that the lease stands on outright, but one very important characteristic of a lease or tenancy is that the tenant will have exclusive occupation. So basically, the right of the tenant to exclude all other people, including the landlord, from the property. In fact, this right, termed exclusive possession, has often been described as the defining feature of a lease. And so for the legal eagles among you, that's the case of Street and Mountford. Throughout the term or duration of the lease, the property is in the possession of the leaseholder, and the land that the property stands on remains in the ownership of the freeholder, or landlord as we commonly call him. And once the lease runs out, the ownership of the property reverts to the landlord. The following few slides will cover the characteristics of a residential let and a commercial lease. Now please note the terminology here, because although essentially they do mean the same thing, when we distinguish between a residential and commercial lease, the terminology differs slightly, but this is purely down to industry standards. What's common to both types of scenario, however, is that they'll both be governed by a lease which sets out the legal rights and responsibilities of each party. So with residential lettings, the characteristics are the most common type being long leaseholds in a residential flat in a block. This is a scenario, there's a long lease term on grant, usually 120 or 90 years. Anything less than 40 years is not considered good leasehold title, particularly to lenders, but this is something your solicitor will advise upon. The tenant normally pays a premium on purchase. for example £50,000, obviously could be more depending on the type of property and the location. And then the tenant will pay an annual ground rent to the landlord, for example £100, £200 per annum. Other costs will include maintenance fees, for example annual service charge, and the tenant's share of the building's insurance. This is normally communicated to the tenant by way of an annual invoice. And the freeholder or landlord, as we call him, is normally responsible for maintaining the common areas such as any estate roads, entrance halls, stairs, exterior structure. The cost of this is normally recouped back from the tenant in the form of service charge mentioned earlier. Leaseholders will normally be restricted from dealing with the property in certain ways. For example, there'll be no external alterations, no internal alterations without permission, no subletting, and no pets. If tenants don't abide by the terms of the lease, for example, they don't pay their rent on time, they breach some of the other restrictions, then this can often result in the landlord taking action, and the worst case scenario, of course, being a forfeit of the lease. A tip here would be to try and get your hands on a copy of the lease before committing to buy, if at all possible. So commercial leases, these are normally much shorter in length, anything upwards of 6 months, most being 3 to 6 year leases, such as lease for an industrial unit, shop, pub, basically somewhere a tenant can run their business from. It's also quite common for these leases to include a break clause allowing one or both parties to terminate early. Unless there are specific contracting out provisions within the lease, a commercial lease will automatically attract a renewal at the end of the lease term unless the tenant has failed to pay rent or observe the lease terms, for example. There can be other reasons as well, such as the landlord requires the property for his own use or redevelopment. There's normally no premium, but the rental fees are normally much higher than with residentials, typically ranging from £8,000 per annum upwards, dependent on the size and type of property and its location. And since these leases are normally for business use, there's often a VAT element to pay on the rental amount. Again, there'll be a service charge to pay, which covers the landlord's costs for repair and maintenance of the exterior parts of the property and structure, which conceivably can be quite costly for large industrial units, where there's a lot of activity going on because of commercial vehicles, machinery and the like. And similarly, with residential lettings, there will be restrictions on alterations. However, you're normally allowed to sublet or transfer and what we call assignment in legal terms to another party. So that is fairly common, although the outgoing tenant will more than likely have to give a guarantee for the incoming tenant, which we call an authorised guarantee agreement. So then we come on to tenancy agreements. Now these normally refer to slightly less complex arrangements, and the most common type of tenancy, which I'm sure you'll all have heard of, is an assured short hold tenancy. We'll call them ASTs for short. Now, these are normally granted by landlords for residential lettings of a whole house or flat. So although initially the arrangement is short term, once the initial term ends, the arrangement will continue until one party serves a notice on the other. So if you're not sure whether your contract qualifies as an AST, it's always best to have a solicitor check through it for you. And to qualify for an AST, the rental property will be private. The tenancy must have started on or after 15th of January 1989. The property will be the main accommodation of the tenant, and the landlord will not live at the property. They're the main characteristics of an AST. A tenancy will not be an AST if it began or was agreed before 15th of January 1989. The rent is less than £250 or more than £100,000 a year. It's a business tenancy, licensed premises or holiday let, or you rent the property from a local council. So I won't dwell too much on slide 12, which details other types of tenancies that exist. Safe to say that because most new tenancies will be an AST, the chances of coming across these on the next slide are quite slim, but you may have heard the terms dotted around, basically excluded tenancies, assured tenancies and regulated tenancies. So what do we do if we enter a lease and we later change our minds? How do we end the tenancy early? So for tenants, the notice period will be governed by your lease or tenancy agreement or by mutual agreement with the landlord. With ASTs, typically request 1 or 2 months notice in writing, but you do need to refer back to the agreement. With commercial leases, you'll normally only be permitted to terminate before lease expiry if there's a break clause, otherwise it ends on lease expiry date. And it's worth saying here that break clauses must be followed to the letter. So if it states the notice must be served on blue paper with yellow dots, then so be it. Landlords, how do we end early? Well, the landlord does not have to give a reason. It's a common misconception in the industry that the landlord has to give you a reason to terminate early. He doesn't. But the following must apply for ASTs. Your deposit is protected in a deposit protection scheme. The landlord must have given you at least 2 months notice in writing to quit, specifying the date that you have to leave. And the date you leave is at least 6 months after your original tenancy began. So that means the first assured short hold tenancy agreement you had when you first moved in. I know sometimes you can have several agreements in succession. So moving on to pension reforms, the government in the next budget plans to announce new pension relaxation rules the 6th of April, and those aged 55 or over will be able to take their entire direct contribution pension savings as a lump sum to invest or spend at will. So as with the current rules, 25% will be tax-free, and property experts I think are expecting a false surge in the market since many people will naturally choose to invest in property. Of course, this doesn't affect all pension trusts. If you do have any queries, please speak to your pension providers or contact our tax experts for a free initial consultation. If the rule changes do affect you, it might be worth speaking to a tax specialist anyway as separate to your normal pension provider, because ultimately they can confirm whether you'll be creating a better return than if you were leaving the pension funds in the pot. And it's also worth noting that there will be potential tax implications on release of funds. So, if you're a landlord, what can you do to make your property marketable or more attractive to tenants? Well, firstly, you need to pick the right area. Employ a local agent, property consultant to source a property for you. More expensive properties don't necessarily make better returns. If you're borrowing, then you'll need to arrange a buy-to-let mortgage, and lenders will typically want to see the rent covering your mortgage payment by at least 125%. You'll need to advertise widely. We are in the information age, so use apps, go online, use things like Zoopla, Prime Location and Rightmove. Agents will have their own method of advertising from usual online sites, their own websites, and of course traditional methods such as newspapers and shop fronts. You just want to cast your net as wide as possible, basically. Tenant checks. You need to do your background checks, your ID checks. Check passports, driving licence, and if the tenant is not British, you'll need to check their permission to be in the UK. I've set out a link there to the Home Office Guide to checking tenants' permissions to live in the UK. You'll need to do credit checks, reference checks. You can employ an agent to do these for you. Many agencies do offer a tenant find service or a fully managed service. So if you want to manage the property yourself, obviously that's probably more economical for some people. You can just get the agencies to do the tenant find for you. I can't stress the importance of all these checks. You need to know who you're renting to. You want to check that they can afford to pay the rent and that they look after your property. And the last point is talk to your tenant. Open the dialogue, answer their calls. Remember, these tenants are ultimately in your house. Happy tenants make for a happy and well cared for house. I've come across so many cases where the landlord and tenant are at loggerheads because of text messages going back and forth. Pick up the phone and ask to visit. Give sufficient notice, do regular checks and ask if everything's okay. Remember, they're paying your rent, which is effectively your income. Look after them and they'll look after your property. And whilst you can evict problem tenants, the process is costly and long. So obviously the higher the tenant turnaround, the longer your property will stand empty, the longer you go without rent, and each time you market the property, you'll have added costs of redecoration and marketing fees, which isn't ideal. I just want to touch briefly on the upcoming election. You'll see the next slide dedicated to the party pledges in the run-up to the election. Naturally, this does affect the market, particularly if you're interested in purchasing for rental purposes. The important determining factor, particularly with lending, is Bank of England base rates and interest rates in general. These will all have an effect on mortgage products, buy-to-let products, etc. So I've just put there the matrix, which you can look through. I won't dwell too much on that because it is getting slightly political, but you can see the main bones of contention between the parties, mainly in house building targets, private rented sector, especially length of tenancies, and property taxes. You can look at that in great detail when you receive the slides. So going back to freehold versus leasehold title then, what are the advantages and disadvantages of each? Freehold advantages: it's more desirable, it offers the best type of ownership and class of title. If the freehold property is subject to a mortgage, eventually you will pay the mortgage off, and as more and more mortgage payments are made, the better the loan to value ratio. In other words, your equity increases over time. Generally over time, the value of the property market as a whole appreciates too. And let's face it, ownership is empowering. You don't have the hassles that come with a landlord, and you can deal with the property how you wish, generally speaking. Disadvantages: ownership of the freehold might mean compromising on location, particularly if you're a business operating in central areas reliant on footfall. Many freehold opportunities are not going to be based in city or town centre areas. To purchase a freehold, you might have to give up, move away from your current space, giving up a well-established location. Landlords always try to replace one industry tenant with another, so it might actually result in a competing business taking your place. It's also likely to be more costly, obviously, than purchasing a leasehold at the outset, but the long-term returns are greater, as with anything. And you'll have to be a handyman, really, learn to deal with things like heating, ventilation, aircon, insurance, basically things that previously your landlord would have dealt with. Leasehold advantages and disadvantages. Well, it's not obviously the best class of title like a freehold. In other words, you won't own the building outright, but you're likely to have more choice with regards to location, desirability, more bargaining power with the landlord where there's a high supply to demand, particularly in centrally located areas. Lease payments will be continuous for the length of the lease term and any extension of the lease, but the more rental payments you make will decrease the value of the lease. You'll be able to call on the landlord to fix any issues, roof repair, structure maintenance, etc. But the landlord might not actually make these repairs, or if he does, he might not do it without some chasing, as many people often find. And you won't be able to make any alterations without the landlord's consent. But if you decide you want to leave the premises, there's considerably less hassle than selling a freehold, provided you exercise your break clauses correctly, and provided upon lease expiry the building is not in substantial disrepair. So in conclusion, you need to assess yours or your client's needs. If they're a startup business, then obviously short-term leases with frequent break clauses might be the way to go. Whereas for cash-rich investors, it might be more desirable to invest in several freehold houses and grant ASTs to carefully considered tenants. And that's the end of the presentation, with the worst picture of me ever on the screen. So we'll now open up to questions from yourselves. Please feel free to use the chat window to email any questions to me. Alternatively, my contact details are on the slide, so you can drop me an email. And thank you for joining me.